Now, guys, there's something you all have to do. Self-managing landlords as well. You all have to do this, and you have 30 days starting tomorrow to get it completed. So, if you have a tenancy with a written agreement, which is a tenancy agreement, yeah, it's a written agreement, then what you have to do from tomorrow onwards is you have to serve what's called the Government Information Sheet. It's called the Renters' Rights Act Information Sheet. And it's a load of waffle, it's about 3 pages, but you must serve that on every tenant. Now, you must serve it on them individually. You should, in theory, because what the government guidance says is that you can serve it via email, but my recommendation to you is you only serve it via email if your tenancy agreement allows for service via email. If it doesn't, I would serve it by post. If you have 2 tenants, I wouldn't send both leaflets in one envelope. I would send one to each tenant, as stupid as it sounds. And just yesterday, I was planning for ourselves to be doing this, and I realised that a first-class stamp was £1.80. When did that happen? It's going to cost us 650 quid in our agency to serve the notices that we need to via post. If they are a tenant, husband, wife, adult son, all named as tenants, then yes, all 3. Whatever's on the tenancy agreement, yes. Now, again, remember I said to you there's grey areas, okay? And for those that have guarantors, you may wish to send a guarantor, a PDF version to the guarantor. That's up to you, that's your choice. As agents, we've decided to go belt and braces because we don't want anything coming back at us. So we are going to serve it to all guarantors via email. Now, if your tenancy agreement allows for you to serve it via email, then that's brilliant. But make sure that you send the PDF, not the link. Do not get that bit wrong, so you'll be fine. But what you've now got to do is document everything that you're doing and everything that you're serving. You can serve documentation via first-class post, and it's deemed served within 2 working days, whether it gets there or not. This is the mistake a lot of people make, particularly when serving Section 21s and Section 8s. If you serve it via recorded delivery and the tenant does not sign for that document, it is not legally deemed served because they haven't signed for it. So therefore, they haven't received it because recorded or signed for, they will only put it through your door once you've signed. So the best method is first-class post or hand deliver, of course, depending on how you're going to do it, okay? If you've just got one property, you can actually go to the post office and say, can I have a certificate of postage? And they will give you proof of postage. We manage over 1,500. We're not going to the post office with 1,500. So we're going to say, what we do is we take a copy of the document that we're sending, a copy of the letter addressed to the tenant, and we upload that onto our file, so we've got proof. And we've done that for years with all of our notices, and we've been successful in court. Recorded is one of the things that a lot of people think that it's belt and braces, but actually it's dangerous. If you can get a response to say that they've received it, excellent. But if you don't, it's just about you being able to prove that you sent it. If you get a bounce back, though, that means they've not received it, right? If you're sending it via email. Every single tenancy, irrelevant of when it started, if it is an assured tenancy or an assured short-hold tenancy, you must do it. Must, absolutely. That's not a no doubt in my mind. We've got tenancies as far back as 1990. All of them needs it, because their contract is going to convert. So let me be clear, this is where you all lambast me now, right? Because I'm a letting agent and this is why you all hate us. Unfortunately, using a letting agent only removes some of your liability, because basically what it means by using a letting agent is that you could make a claim against a letting agent if they behave negligently and put you in a position where you were prosecuted for Housing Act offences. Now, in this specific circumstance that we're talking about now, landlord would still be liable if letting agent didn't do it. So what I would say to all of you that are using letting agents is just ask for evidence that it has been done, because you do need to make sure that you protect yourselves. If there are letting agents out there that are not doing this, although there probably is, I'm not going to be surprised, because we're an unregulated industry, it is also, let me just be clear, a legal responsibility for you as landlords lies with you, but if you have a managing agent, it is actually the responsibility of the agent to send it. So if an agent doesn't send it, they too can be fined, but that won't help you because you will still be in breach. Every single contract that we have will be in breach. That's the way you need to look at it. Every contract will be in breach because the law has changed. Service of these two things, we haven't even talked about the written statement yet, but I'll get onto that in a moment. Service of these two things is what takes the tenancy out of breach, if that makes sense. So failure to serve this keeps your tenancy in breach. And therefore, that's why it's so important. Just before I go on to covering letters, let me explain. For those that don't have a written agreement, and I think we worked it out the other day, out of all of our properties, Alicia, I think we've got about 45 that don't have tenancy agreements because they've been management takeovers or the tenancy agreements got lost over time. If you physically don't have one, you now have to serve what's called the written statement, not the leaflet. It's a bigger document, it requires certain information, and that has to be served in place of the leaflet if there is no written tenancy agreement. The government website has both the written statement and the renters' rights information sheet, so you can download them from the government website. But just again, I mean, it doesn't really apply to here, but what a lot of people did is they jumped up and thought they were really clever and, oh, we've sent it already, we've done it already, oh yeah, you know, it was nothing. And then on the 22nd of April, they actually updated the government information sheet. So anybody that had sent it prior to that date now has to do it all again. So I always had said, look, it doesn't state you can't send it before the 1st of May, but I know the government and I know their legislation. They make changes right up until the last minute. So we said, we're doing it after the 1st of May so that we only have to do it once. So if you did do it before the 22nd of April, guys, it's going to be the wrong one. There was an update that was made, and if you go again onto the government website and have a look, it will tell you the change that was made. So you're going to have to do it again because you do not want to risk it being the wrong one. There's two things that I just want to talk to you about because some of you raised your hands and said that you've got existing Section 8s and Section 21s out there, haven't you? We need to put in this email a covering letter. So she said, what happens if I've got a Section 21 that's already out there? Do I still need to serve the information leaflet? The answer is yes, you do, but you need to put a covering letter. Well, you don't need to, but it will be best practice to. Now, I created the covering letter, and it basically says, hello, Mr. Tenant. In line with government guidance, we are providing you with the information leaflet as legally required under the Renters' Rights Act 2025. Please note that this has no effect or bearing on the Section 21 notice that has been served on you, and possession is still required, and proceedings will continue as normal. And you do the same for Section 8, but you just change it to Section 8. I actually went one step further, and I did a different one for those that are in fixed term, because I wanted to be clear to them that your fixed term has now ended, and then I did one to everybody in periodic, so I did 4 different templates. But also what I did, because if you have a tenancy agreement that states that the tenant only has to give 1 month's notice, there's an argument that they still only need to give you 1 month's notice. Now, it's an argument that I don't agree with, but I don't agree with a lot of what they do. So in your covering letter, you make sure that you also put in there that, please note, under the new law, statutory notice period for tenants are 2 months in line with a rental due date. We intend to rely on statute notice. Okay, so just a little bit of a clause. So the covering letter is really important, particularly with your section notices.